I will now share my slides with you. And if my colleagues can point to me that I can be heard well and the slides are working well, I will kick off.
Yep.
So just a reminder, we are in the access to justice, how to get access to information and prepare complaints. We had the first session by Trish. And just to give you a schedule on what is expected today, I will now talk about individual, collective, and public enforcement. Then we're going to have a coffee break, and there will be an interactive session, a discussion with you, how to approach cases of discrimination. You can get involved, no obligation, but would be great for the conversation. And then we're going to finish with an update on ongoing work of the AI office with some of the things that are currently coming out of the AI office. So I wanted to just very briefly share some key takeaways with you. Not all of you have been there in the first seminar, also to make the bridge between the webinars 1, 2, 3. And that is, we first of all learned a lot about the legal framework and what is the AI Act and EU non-discrimination law when it comes to discrimination. That was the first thing we talked about. And also to say the recordings will be most likely available afterwards. You're going to have documentation, you get the slides, so you will be able to dig into it even if you have not had the time to follow. Second, Aaron told us about demystifying AI, how AI systems function, all the complexities, and we need to learn the same language. And then we also learned about the design rules. Finally, we touched a little bit on the differences of traditional complaints under non-discrimination law and those that are possible under the AI Act, and we're going to go into that also a little bit today. And finally, we explored some of the challenges. That just as a reminder of those of you who were not there in the first seminar. So to start with what Trish said, I will not repeat it, but I would like to recall the importance of recital 27 on transparency for the things I will say in the next few minutes. So it's a good transition. And I would also like to remind, as Trish has touched upon a little bit, that high-risk AI system provides some requirements, and this can be very important in the context of transparency information requirements. So it's very helpful for civil society organization and equality bodies because we know the information is somehow out there. I also wanted to recall briefly, before I go into the enforcement part, the importance of the EU database. It's for high-risk AI system, Article 71, and this can be a very good source of information. I will now start with the substantive part on the enforcement, but if we have time, we can go back to that, and you will also have the slides just to flag this. There are many provisions out there that provide public access to information that you can make use of. So now on individual, collective, and public enforcement. I divided this into three parts because we have the individual enforcement, we have collective enforcement, and we have something that I will call generally public enforcement. You will also learn later why all of these provisions are in there, Article 77 and so on. So let's start with the individual enforcement. One of the great things that the AI Act provides is a right to lodge a complaint, and that's Article 85. To whom does the complaint need to be directed? That's the market surveillance authority in your member state. So you have to see which one got defined. Most of them have been defined now. And this right to complain, and this is important to know, it is without prejudice to any other administrative or judicial remedies that are available in the member states or elsewhere on EU level. And so discrimination complaints or judicial proceedings can go along. So this Article 85 in a way can be complementary. So be aware of that. You can use multiple routes to kind of complain. Who can complain? Any natural or legal person. So it's not only individuals, but it's also legal persons who can complain. So any company, any competitor, for example, that thinks that another competitor did not take the administrative burden and the time to do these things, you can complain for that if you have a violation of the AI Act. And what do you need for this right to be triggered? You need to have grounds to consider that there has been an infringement of the provisions of this regulation. So this can be any infringement. If we take the case of a high-risk AI system, as Trish already alluded to, some requirements need to be fulfilled in terms of documentation, logging requirements, risk management system, and so on. If a deployer didn't do that, that would be an opportunity to complain because it's mandated by the AI Act to do that. And so in the end, you can submit a complaint to the relevant market surveillance authority. So Something more on Article 85. Complaints, and that can be quite interesting. And I'm saying here, everything we suggest in the seminar, of course, cannot be regarded as an acceptable as an interpretation of the AI Act. That's for the AI Office to specify, and of course, for the European Court of Justice has the sole authority to say what the EU law says and means, and for national court to interpret the EU law. But these are just some kind of guidance that we're trying to give on this basis, just for that to be clear. And so, because this is important for the next point that I'm making, because Article 85 says the complaints shall be taken into account for the purposes of conducting market surveillance activities. And this is a good opportunity to flag to you that Article 85, the right to complain, is not exactly the same as a complaint for non-discrimination law under your national law. Because this is not a complaint on the basis of a violation of the principle of equality, for example, between women and men. It is a complaint where you can flag something that there's a violation of the AI Act. So very often there might be a link if you're talking about the requirement to conduct bias audits, or if we're talking about Article 27, Fundamental Rights Impact Assessment. If this has not been done, there is of course a link with equality and non-discrimination, but you don't flag in this complaint directly a violation of the principle of non-discrimination. This is important to note. And so if you complain, this can be taken into account by the market surveillance activities, authorities, and so it's a little bit unclear as of yet what this really means. They can take into account. It's not clear whether there's it's mandatory. They need to do it. But everything they learn in this procedure, so it's still important to use it and to make use of this mechanism, will be brought to attention of the market surveillance authorities in the member states. And then there can be, we're going to come to that, there's cooperation between the different authorities. It might lead to other cases being pursued or something to be undertaken so that this violation is for sure corrected. For example, if no bias audits are done for high-risk AI system, this can be a corrective action afterwards. And all of this shall be handled in line with the dedicated procedures established in the member states. So that's Article 85. Now, very complementary is Article 86. So the right to get an explanation of the individual decision making, and that is a very important right as well. What are the conditions for this right? And it's coming a little bit from the GDPR, from data protection context. We're going to come to that in a moment. So it's not completely, this type of thing is not completely new. That has been included in the AI Act. So what are the conditions for this right? The conditions for this right are basically any affected person or subject to a decision can use this right for something that is taken by the deployer on the basis of the output from a high-risk AI system. So high-risk AI system, we heard it already. You need to look in a nutshell in Annex 3, whether you're in or out. And this individual decision needs to produce legal effects. But that is not the only condition. It's either legal effects or similarly, significantly affects that person in a way dare to have an adverse impact on their fundamental rights. So what does it mean? It's a little bit unclear what that means. There's no legal definition what it means. There's not a lot of specification, but we can look into other things. I'm going to show you this on the next slide, but I just wanted to make clear that you have to be individually concerned by a decision. So, for example, if you are addressed by an AI recruitment system and you're not taken for a job, this is potentially a legal effect. Or if you, for example, not promoted, because it would, in terms of non-discrimination law, fall under Directive 2006/54, access to the labor market, and once you're on the labor market, so that would be a legal effect. But if you have something that does not cross the threshold of a legal effect, you can still make use of this right, and that's the similarly significantly effects that you have here on the slides and in Article 86, and that is important to know, notably in the context of equality and non-discrimination, because very often we have something that is terribly bad for an individual, but it does not cross this threshold. And in this case, you still would have the right to an explanation. So what is the outcome if you exercise this right? You are given clear and meaningful explanations of the role of the AI system in the decision-making procedure and the main elements of the decision taken. So that sounds quite good. You get clear and meaningful explanation and the main elements of the decision taken. So that's very good, actually. If you think there is something in the context of discrimination, there's a problem, you receive a very good explanation of what has happened and the main elements of the decision taken. So that could give you a first hint on what to do afterwards. For example, it could give you prima facie evidence that you might want to use because you're an individual, you can collect this information, and then you can, if you have been affected by this AI system, potentially go under non-discrimination or make a complaint. So have a separate way, not only a Article 85 complaint on the basis of the AI Act. So that's very good. I promised you GDPR is somehow has something to say on that, and this is something we find in the GDPR as well. And so there is the Article 29 working group that issued guidelines on automated individual decision making in 2017 and updated in 2018. And if we look here, we're going to post this in the link or send you afterwards the details, of course. But page 21 states that the threshold for significance must be similar to that of a decision producing a legal effect. So we have the same distinction here between legal effects and sufficiently significant, because this guidance tells us that at the same time it specifies that it is difficult to be precise about what would be considered sufficiently significant to meet the threshold, although the following decisions could fall into this category. So when you read this guidance, you get more information, but it's also not entirely clear what it actually means. So there will be room for interpretation. Maybe there will be guidance coming, or the courts would need to interpret what this actually means. But very helpful, and maybe as a takeaway for you to remember, is the examples that are given on page 22. And that is, for example, decisions that affect someone's financial circumstances, such as their eligibility to credit, or decisions that deny someone an employment opportunity or put them at a serious disadvantage. So we have a little bit of more specificity here. Of course, this is in the context of GDPR, so be cautious when you bring this over to the AI Act context, but at least it's something, guidance issued by an EU body or by the independent Article 29 working group, so the member states are behind it. So it could be useful. And eligibility to credit, we know there are cases with problems of non-discrimination on the basis of race, religion, and gender, and employment is a big bucket of cases as well. So it might be very helpful to look into that. And then I don't want to go into the details here, not to navigate too far away from the content, but the GDPR's right to explanation, of course, gives further guidance. So please look into Article 21. Paragraphs 1 and 2, their Articles 13 as well is about information requirements, Article 15, right of access to meaningful information. So here again, you have the term of meaningful information that is very similar. So please look into Article 22, 71, the recital, that also refers to the guidance I was just referring to. So that can be very useful. Also, just as a reminder, and we don't have so much time, but there are some cases you might want to look into. For example, Caisse Nationale des Allocations Familiales provides some further guidance, or also one of the first cases of the European Court of Justice, the Land Hessen case, which was on the automation and the production of legal or similar significant effects about automated decision making. So there's some interesting elements also in there that might be helpful. And there's a German Bundesverwaltungsgericht case also on automated scoring mechanism that might be interesting. And finally, the French Conseil d'État case on the Parcoursup system. So all of that could give you some guidance. So don't forget, if we talk about these Article 85, 80, 86, please look into GDPR and what's out there. It could be helpful. And I'm sure many of you are also coming from this background previously. So be aware of that. Now, an important point. Article 87 is not exactly a right to complain, obviously, as you know, but it's a very important provision to mention in this context because it's about whistleblower protection. So we know it's very important, and we know cases, all of you know cases from across the Atlantic where basically people were complaining in relation to AI tech companies and highlighting some things that were not going well. And so it's important that Article 87 in the AI Directive ensures whistleblower protection. So anybody who wants to exercise these rights is somehow protected. So it's good that it's out there. And this is, of course, important because the persons who are in an AI company might know about stuff that is not very good. And so if people know that something with data sets or the design of an AI system that could impact discrimination is going in the wrong direction, people can flag that. And they know that to some extent they are protected. So it's in a way an encouragement to kind of make use of these useful resources, because it's always very difficult, of course, to get access to that. So that just so that you know that Article 87. And now we come back to complaints. I've been talking about Article 85 and 86. Complaints on non-discrimination law. Of course, many of you are experts on this matter, so I don't need to go into very much detail here. But equality bodies are there for national complaints. You can complain to the court. And in all member states, there is at least one body who is dealing with that, who is responsible for giving, for example, advice or independent assistance to victims of discrimination. The powers of equality bodies vary, of course, in the member states. You all know that. But there are different things that equality bodies can do. You can go to court. You can also be assisted by equality bodies in some member states. You can bring cases in your own name. And some equality bodies can also act even as nearly as a court with very strong powers. So all of that is a possibility, and this is alongside, I need to emphasize this, alongside the AI Act complaint. So you understood from what I previously told you that the AI Act complaint, Article 85, is not a complaint of non-discrimination law. So you cannot directly claim, I have been discriminated on the basis of my race, my religion, or my gender because of this AI system, and so now I want to have compensation, or I want to get something else. That's not the case. It's distinct, but it's complementary, and sometimes it can be really complementary, and sometimes it can lead to information being collected and being used. So use the two roads in a case. Always reflect that you always have multiple roads, and of course we're going to come back to that. You can also always think about other legal mechanisms like consumer law. We're going to come to the redress, so then we always need to think about the different routes that are available to you. So now the second pillar after individual enforcement is collective actions. So Article 110 AI Act is quite convenient because it refers to the Representative Actions Directive, Directive 2020-1828, which aim is, of course, to improve consumers' access to justice. That's what Article 1 says, to set out rules to ensure that a representative action mechanism for the protection of the collective interests of consumers is available throughout the EU with appropriate safeguards to avoid abuse of litigation. So that's out there. And so basically it changes the directive and includes the AI Act of being one of the applicable directives where you can do collective actions. And if you're further interested, you can notably look into Article 2.1, the scope, and point 68 of this legal act where the AI Act is included. In a nutshell, it says that infringements of the AI Act can be challenged under the collective redress directive. So always think about it if you have a case. This type of redress is different from collective action under non-discrimination law, but it can still be useful to flag non-compliance with the AI Act, which might indirectly undermine the enforcement of non-discrimination law. And then also always think about the actio popularis in general, also in cases of non-discrimination, because it could reinforce and complement where this is available. And here, see also the new EU Directive on Standards for Equality Bodies that refer to it in its Article 10. And if you want to know more about it, Equinet has a very good publication, Understanding the New EU Directives on Standards for Equality Bodies. It's available on the Equinet website. So now we move to the third pillar, public enforcement. So I put a few things here on the slides, Article 77, cooperation, Article 74, but also Article 27. I just want to warn you from the outset, don't be surprised that Article 27 is here. It's, of course, you all know that, not an enforcement tool as such, but I put it here for the purpose of general understanding and understanding where the public basically can be involved in ensuring that the rules are enforced. And Article 27 is, of course, a fundamental rights impact assessment, and this only applies to public bodies. You only need to do it when you're a public body, or when you operate in a sort of natural monopoly and you are on behalf of the public sector. Then you need to do a fundamental rights impact assessment, and this is a brilliant tool. In a way, you indirectly ensure public enforcement because it's mandatory to do that, and the public is involved, and the public is, of course, bound by the Constitution, by the Act of Member States, by fundamental rights, and so on. So that's interesting. That's why it's here, and we're going to say a few things on it. But the main important point is Article 77, which Trish kindly introduced already. So you all know that Article 77 gives a prominent place to national authorities that enforce fundamental rights. Most often, or ideally, I would say, equality bodies. And then we have the cooperation with other bodies, Article 74.10 and others, where different authorities, notably the market surveillance authorities, need to cooperate with other national bodies, for example, Article 77. So that's what I want to talk about in this public enforcement section. So Article 77, powers of authorities protecting fundamental rights. What we need to do is, we don't need to go into all the details because some of the things have been said already, but that is the natural domain of equality bodies. So who is basically addressed? It's national public authorities or bodies which supervise or enforce the respective obligation under EU law, including the right to non-discrimination. And here we have a reference to potentially flag that it would be very good to include equality bodies in there. Of course, other bodies like the GDPR authorities also have rights there, and there are many other. We will see what bodies are nominated, so that's a parapluie of many different authorities. But the first thought naturally comes to equality bodies because they enforce non-discrimination law. They're kind of protected and are operating in this area. So what does Article 70 say? It says these bodies shall have the power to request and access any documentation created or maintained under this regulation in accessible language and format when access to that documentation is necessary for effectively fulfilling their mandates within the limits of their jurisdiction. And so that is very interesting. They will have the power to request and access documentation, which can be very useful for preparing non-discrimination cases, but also, and I think that's a very, very strong wording potentially, that is necessary for effectively fulfilling their mandates. And here I think equality bodies, civil society can play around with this and kind of interpret that in a way to say, depending on the powers that equality bodies have in the member state, they will have different powers because they might request more, because if not, they might not be able to effectively fulfill their mandate. So it might be different actually in member states what they can request, and depending on the authority, there are also different legal powers or only advisory powers. So you need to read this carefully and reflect and see what this means in your particular context. But we of course have to wait for interpretation on this point. But I just want to highlight that it's not only about having the power to request and access, but it's also, it needs to effectively fulfill their mandate. So if they cannot effectively fulfill their mandate, maybe the power to request certain documents is not sufficient there, then maybe needs to be more. And when there needs to be more, there's also, yes, by the way, normally until November 24, Article 77.2 said member states needed to notify or to nominate the bodies. This has not been the case for all of them currently. Just to give you two examples, in Portugal there are 14 bodies that have been nominated. In Spain there are 12 alongside the AECA, which is the Market Surveillance Authority. So just to give you the illustrative long list of bodies that are considered as Article 77 bodies. That's from February 2025, an overview. In terms of Article 77 bodies, it's basically half, it's a bit unclear as of yet, and for half of them it's clear who it will be, like the lists I showed you of Spain and Portugal. So that's still ongoing. Please look into the AI Office website, what's the latest state there. But now back to Article 77. If 77.1 of the information you need and you will get is not sufficient, we come into Article 77.3, and that is a really strong power for equality bodies or any other body that has been notified under 77. Because if this documentation is not sufficient, so insufficient, to see whether an infringement of obligations under union law protecting fundamental rights has occurred, so that includes all non-discrimination law. If this is the case, then the Article 77 body can organize, together with the Market Surveillance Authority, who is in charge, organize a testing of the high-risk AI system. And that, as Trish said, can be very fundamental because it's in a way opening the black box and trying to understand what's going on. So this organization of testing the high-risk AI system through technical means is really key and really should be used if necessary and the conditions are fulfilled. because this really can discover a lot of information that could be evidence in a non-discrimination case. So that's very useful, and please always think about that if you're confronted with a case of discrimination. So now briefly on cooperation, Article 74, and are going to be a few minutes longer. Apologies for that, but we're going to save that later, as it will be a bit shorter. So Article 74, 10 on cooperation with other bodies. It's really important to look into all the provisions that are in the AI Act on how bodies cooperate, because you have some legal hooks in there. Some of the conditions will be specified under national law with the implementing acts, but it's very important how they interact, notably Article 77 bodies and the member states authorities, also because very often the member states authorities have a little bit more powers and are often in the driving seat. So it's important to use fully the rights of Article 77 and really cooperate and engage actively, proactively to make sure that all the possibilities are basically used, that equality bodies and all those who are designated as Article 77 are used. So in a way, Article 74 deals with the market surveillance and control of AI systems in the EU, and in essence, it says there shall be a coordination between market surveillance authorities and other relevant national authorities or bodies which supervise the application of union law that might be relevant for the high-risk AI systems referred to in Annex 3. So notably for high-risk systems, this cooperation is very important. And even if you're not notified under Article 77, you are an equality body that would not fall under it, you could still rely on this in order, when it's a high-risk AI system, to kind of cooperate. So please look into all the possibilities that you have out there in the AI Act. And so it would be very good if we get a little bit further guidance on that, obviously, to be seen whether this is coming. Notably because, as I showed you with the examples of Spain and Portugal, there are different authorities that will be nominated and responsible for enforcing the AI Act. And so sometimes equality bodies are in, sometimes not. And so it's important to kind of cooperate among equality bodies, but also with the competent authorities, that you make sure you value your mandate. Even if you're not nominated, you can potentially do that. It's written in Article 74. A second article I wanted to flag in terms of cooperation, it's Article 79, which deals with procedure at national level for dealing with AI systems presenting a risk. And this is basically about risk evaluation of market surveillance that is done by the Market Surveillance Authority. And why is this article important? If you look in Article 79, paragraph 2, it's subdivided into two big chunks. You look further down and you see that it speaks about the cooperation with national Article 77 bodies. And it speaks about the possibility for corrective action. So here also the cooperation is mentioned, and always look for these provisions where you can use your powers to cooperate, because you can rely on these provisions to say, look, we need to be at the seat, we need to have a seat at the table, we want to discuss these cases.